There's been a lot of controversy lately coming out of Portland, and I thought it might be helpful to share from a lawyer's perspective, at least one lawyer's perspective, some thoughts on the legality of the use of troops by the Department of Homeland Security. And I want to focus your attention on one particular arrest. I've chosen this arrest for a couple of reasons. The first is because there's video of it. So I'm going to play the video first. It's disturbing.
What are you doing? Use your words. What are you doing? Use your words. What are you doing?
I haven't done anything wrong.
Use your words. What is going on?
We need to know.
Who are you?
Why are you taking
NLG will get you out. What's your name? Tell us your name.
What's your name?
Okay, you're fine. We'll get you out.
Bro, what? All right,
We got you, friend.
we got you.
Oh fuck!
NLG.
You just violated their rights.
So did they violate this individual's rights? That's the legal question. To answer that question, I'm going to turn next to video of Deputy Director Chris Klein of the Federal Protective Services answering some questions about this.
Federal property. So in this instance, you're probably talking about the van. So the CBP, the Border Patrol officers, have been cross-designated with our authority. The individual that they were questioning was in a crowd and in an area where an individual was aiming a laser at the eyes of officers. We have people in the area that observe, keep track of him, where he's going. We don't want to go in the crowd because then it's a fight between our guys and the demonstrators. So we wait till the individual gets into a somewhat quiet area where we don't expect to have violence when we want to talk to him. In this instance, the CBP officers approached him, and you saw the approach. It was peaceful. There was no tackle. There was no get on the ground. They wanted to talk to him. But as they approached him, they noticed that coming in their direction were violent demonstrators that now see what's going on, and they want to go help. So they asked the individual, please get in the van, and they did take them to an area that was safe for both the officers and the individual to do the questioning. So it's not a custodial arrest. We need to question this individual to find out what their role was in this laser pointing. And unfortunately got kind of spun out of control with the rhetoric about what happened. It was a simple engagement. The individual was with the CBP officers for less than 20 minutes while they did the questioning. They had to get out of the area so they weren't attacked.
There's several points I want to make about this, but the first one is, notice that Deputy Director Klein admits that they didn't have probable cause to arrest this man. Specifically, he doesn't describe officers as having seen this man commit a crime. They say he was in a crowd near a person who shined a laser pointer at a police officer's eye.
The individual that they were questioning was in a crowd and in an area where an individual was aiming a laser at the eyes of officers.
Now, does being near a person who commits a crime give officers probable cause to arrest you? The Supreme Court answered that question in a case called Ibarra versus Illinois in 1979. A person's mere propinquity, great word, to others, independently suspected of criminal activity, does not without more give rise to probable cause. Where the standard is probable cause, a search or seizure of a person must be supported by probable cause particularized with respect to that person. Propinquity just means nearness, being near a person. And notice that they point out that the probable cause must be particularized with respect to that person, meaning if you have probable cause because this person in the crowd committed a crime, your probable cause is particularized to that person. It is not probable cause to anyone in their propinquity. The second point I want to make is that this individual was in fact arrested.
So it's not a custodial arrest.
In a case called Dunaway versus New York, also in 1979, the U.S. Supreme Court addressed the situation of when a person is taken, transported to the, in that case, police station in Rochester, and then questioned by police. It constitutes an arrest and therefore requires probable cause. And if you compare that to what happened in Portland, it's the same thing. They took him, transported him, in this case in a rental van, and questioned him for, in their words, approximately 20 minutes. You may remember that Deputy Director Klein emphasized this is not a custodial arrest. He's wrong. This is a custodial arrest under clear U.S. law. And if you're wondering what he meant when he said, once the U.S. attorneys showed up, We didn't have what we need.
And then they conducted the questioning and they released the individual because they did not have what they needed. The U.S. Attorney's Office is consulted on every engagement that our officers are doing.
He's likely talking about probable cause. They did not have probable cause to make the arrest. There are a lot of things alarming about this story. There's a lot of things alarming about what's happening in Portland. There's a lot of things alarming about the idea of the use of these sorts of forces being expanded to other cities. For me as a lawyer, perhaps the most alarming is that DHS is holding a press conference seemingly unaware that they are describing conduct in violation of the Fourth Amendment, basic Fourth Amendment law, by their own agents and officers. If there's one thing you hope for in a law enforcement agency, it's a basic understanding of the law governing arrests. And this press conference seems to demonstrate that they lack some of that. I hope this was helpful. My information is on the screen. It should go without saying that none of this is legal advice. This is all just statements of my opinion. But if you do need legal advice, feel free to give my law firm a call at the contact information provided. Have a nice day.